Thank you so much for staying on this channel. This is Law School Made Easy at Law School Made Easy. Thank you so much for subscribing, for liking and sharing our videos. The only motivation we get colleagues mutuyambe subscribing, tuchitaga banange subscribing, musharing, muliking, wacholaba to subscribing gemanyi naffe getufuna ng'abantu netuleta videos netukuwa netuzikola nezijja. But we thank you so much. Today we want to look at what we call the Repungancy clause. You remember in the Order in Council 1902 we had Article 20, Clause 20 of the Order in Council that created the Repungancy clause, and the question is here. We want to look at what do we understand by the word Repungancy clause, and then what did the British mean when they introduced the Repungancy clause, and after we shall focus on the 1995 Constitution, that what happened after, that up to date when we go to the 1995 Constitution, do we still have Repungancy clause valid? Is it still there? Is it valid? What were the effects up to now? Has it affected us basing on the cases we had in the past and the cases we have today? What do we mean by repugnance? Repugnance as a word, it can mean inconsistent. To the literature student, it can mean incompatibility, that something which is inconsistent with either the existing laws. So in this matter, in this case, the British said that some of our laws were repugnant, that they did not reach the standard. They were repugnant to the English laws. They were even repugnant to the doctrines of natural justice, to the doctrines of morality, the doctrines of equity. So we are saying this repugnance inconsistent. How was our laws inconsistent, or how were our laws repugnant? Number one, let's look at the case of Ara versus Amkeyo. In the past, but remember in this video, we want to look at the effect of repugnancy after the introduction of the 1995 Constitution. In the eyes of the British, Lord Amon, in the case of Ara versus Amkeyo, this is a Kenyan case. In this case, one man, Amkeyo, stole a cattle and used the skin to sleep on it and so many things. Now, when he was held and taken for prosecution, the argument was, is his wife supposed to give testimony against him? The question was that no, the wife is not supposed to give testimony against his husband, to give evidence against his husband, because we assume it is presumed to be one. That was the English setting, the English law. That is what they used to believe in. But Lord Amon said, in this scenario, the wife of Amkeyo is supposed to give evidence, simply because that our marriage was not considered as the one that was valid. Our marriage was considered to be the one that is mere wife purchase. That our marriage was a mere wife purchase, because in the process of contracting, of getting married, of having a wife was considered to be a chattel, to be a property, and the idea of giving in bride price was not welcoming to the British at the time. Then, secondly, that a wife was not a contracting party, that most of the discussions were held between the parent and the side of the man, and the woman was not a contracting party. So therefore, it did not pass the test of natural justice, morality, and consciousness. It never passed the test, and therefore, the woman in Ara versus Amkeyo was allowed to give evidence against his husband. So meaning that our laws, our type of marriage to the British way, it was repugnant. But of course, in the subsequent videos or in the subsequent course, you find that the principle of customary marriage originated from this case. So that is the case of Ara Amkeyo. The take home is very simple. Amkeyo's wife was allowed to give evidence, yet in what was considered to be a good marriage in the Indian Act that we're using at the time, which we had received during the reception clause 11th August 1902, a wife was not supposed to give evidence. So I want to refer you because we want to now go to the gist of the matter, the bone of contention, which is the 1995 Constitution. That what happened in the coming of the 1995 Constitution? Did we drop at any one moment? Did we drop the repugnancy element? Is it still there? Is it still existing up to date? But before I go there, I want to refer you to a case of Chirimo versus Chisunda. In this case, a father they suggested to take his property because his son had done a wrong. So your son commits a wrong and it is your father to pay. And so we are saying such was repugnant. But I urge you to read Chirimo versus Chisunda. Let us go to the effects of the repugnancy clause after the introduction of the 1995 Constitution. In our country, Uganda, when we introduced the 1995 Constitution, you find that up to now we are still affected by the repugnancy clause, which was introduced in 1902. That up to now there are cases which have been decided that saying that some of these values or cultures that we believe in are still repugnant. Let us take a case of Bruno versus Ivan Serunkuma and Juliet Namazi. In this case, Ivan Serunkuma and Bruno Namazi, they all came from the same clan. They were of the same clan, I think that is Indiga. They came from the same clan. And coming from the same clan, they wanted to marry. But it was held in court when the father, Bruno Chihuwa, was reporting them. It was held that in the Buganda culture, you cannot marry your sister. If you come from the same clan, you are regarded as sisters. So there is no way that would be happen. And allowing it to happen, it would be violating the rights. One, the culture of Uganda, so it was considered to be inconsistent, to be repugnant with the cultural values and cultural norms of this country. And that is why that case did not succeed. Ivan Serunkuma and Juliet Namazi did not move forward. We can have another case as an example. Let us take the case of law and let us take a case of, I think it is law, it keeps skipping my mind, it is law and advocacy for women versus Attorney General. It keeps on skipping, but I think that's the case. I beg you cross-check, but it must be law and advocacy for women versus Attorney General. In this case, they were contesting the female genital mutilation, the cutting of the clitoris, the women clitoris that usually happen in Eastern Uganda, in my favorite area, that is the Kapchorwa, Sebei area, that it was causing a lot of pain. It was inhuman treatment. We have a full article, Article 24, describing inhuman treatment, that doing it, continuing to practice it, it was repugnant with our Constitution, violating Article 24 of the Constitution. It was repugnant with our cultural norms. So you can see that even after the introduction of the 1995 Constitution, you find that the repugnance clause is still making a lot of sense. It is still working a lot. So that is what we mean by repugnance clause. We can take one more example. Mifumi versus Attorney General and Kenneth Kakuru. In this case of Mifumi versus Attorney General and Kenneth Kakuru, Mifumi, an organization here in Ntinda, was contesting the idea of bride price, which was held that it is in form of appreciation. But the idea of returning the bride price when there is a divorce, really, it is tormenting the parents. It is tormenting the parents. It is more so inhuman treatment to the parents, and it was not accepted. And the court held that the returning of bride price after marriage is not really accepted because it would cause a lot of problem. So I urge colleagues to continue and read the case of Mifumi versus Attorney General. And finally, maybe we can look at the case of Bestike Migisha versus Mebo Komuntari. In this case of Bestike Migisha versus Mebo Komuntari, that when the husband died, Bestike Migisha was not allowed to take possession of the property of the husband. But court held that, yes, even a woman can still take possession of the property of the husband. So you see that in this case, the people who were saying that she's not supposed, they were still following the Repungancy issue. But now we are saying we are moving forward. Even a woman can take control of the property of the husband. So, and more cases about Repungancy clause. But we urge you to subscribe, to share, and like our videos. That has been the Repungancy clause. Thank you so much. Until next time.